So we spoke about corporates and commercial entities. Now, talking about PSUs and the role of bar and bench in considering mediation to resolve the disputes, because again, PSUs and government entities have the most amount of litigations going on in the country, and bar and bench plays the most important role. So, what would you comment?
So, for the bar and bench comprises of lawyers. So, therefore, the first comfort, and rightly so, that they seek is a strengthening of the or strengthening, or not strengthening is not the right word, probably augmentation of laws relating to mitigation, because they feel comfortable staying within, dressing up in a cloak of law. That is what their profession is. So therefore, if we are able to have a more clearer set of legislations or rules or regulations relating to mediation, that would automatically facilitate and encourage both the bar and the bench to get more supportive of mediation. And the government and the higher judiciary is extremely seized of this matter. And as we speak, as you are well aware, there are a number of high-powered committees, both at the government level as well as the judicial level, which are looking at this. So I'm sure that over a period of time, this will get done. And once it happens, you will find that there will be an inflection point in the support that both the bench and the bar will give to mediation. Having said that, I think in the bench, the recognition to give support to mediation is greater than the bar. And the reason for that is the bench, the judges are overwhelmed by the number of cases. In fact, sheer necessity provides them with, the reason for, allowing people or encouraging people to go for mediation, because it takes away the pressure of, the pending cases and pendencies that they have. And some of these cases, no judge wants to dismiss any case unless extremely flippant. Because as I said, anyone filing a case, we have to respect the dignity of that person. But they know that this is not a matter where, they will be really called upon to exercise their intellect and knowledge to resolve it. So better to push it. So that has been happening. The issue that I see is in the bar side, and they'll divide the bar into two parts. One is the counsels, the practicing counsels, those who are the role of advocates, who actually go and, who are involved in advocacy. And the second one is the solicitors, who actually advise clients. For the second plot, my view is that over a period of time, as it has happened in many other countries in the West, the disputes practice of big law firms and even smaller ones, currently they are probably focused only around litigation and around arbitration. But I think it is going to be a matter of time before mediation will also become an important pillar. And the reason for that is people come to a lawyer when they are vulnerable, when they have some concern. Nobody comes up to a lawyer feeling greatly happy about it, And so therefore clients are seeking a solution. And particularly if there is a dispute-related problem that they have come to, it's a very stressful situation when the client comes to a lawyer. If the client offers a solution, agnostic to whether it has been delivered to a court or to an arbitral tribunal or to a mediation or conciliation, it would have made a huge difference to the client. And even from a law firm perspective, it might end up in a much shorter period of time than a normal litigation would have dragged on, but you would have given so much of delight to a client that the client would have come back. People who are, advocates, actually go and plead in courts, first and foremost, because of all this online and virtual system, the whole concept of advocacy will change. I think, there will be less of oral arguments, more of documentary-led evidence. Because if courts have a limitation on how many people and how much time they can give for physical arguments, I think you will find that there will be a great movement of people preparing the documents which will get studied by judges much more than people coming and arguing. There may be a short argument, it will not be an elaborate theatrics that often go on in courts today. That in rare cases where it's a big constitutional matter or something. And second is that even counsels, counsels by very nature, they are very respectable people of society. They deal with a variety of cases. Their commercial acumen is of the highest order. And if some of them not only remain an advocate, but also choose to become a mediator, bringing to bear not only their legal skill, but also their commercial judgment, their stature, their gravitas, I think this will become a very important form of practice for even counsels. And I can tell you that if they do it well, like, there are so many retired judges who make excellent arbitrators. Probably they excel in it as much as they excel as distinguish themselves as judges. Some of the counsels today, if they take up mediation, they can probably have as much satisfaction both professionally and economically and financially. So therefore, you will see those changes happening. It may not happen with immediately the generation that is there today, but it is bound to happen with the younger generation. Even advocacy-oriented lawyers will choose to be mediators as well as arbitrators. So these changes are going to happen.